All right. Good afternoon. My name is Justin Grimske. I am a partner at Secrest, Wardle. Today I'm going to be discussing two topics. First is premises liability and general/ordinary negligence, which I'll be using those two words interchangeably. And then second, I'm going to be discussing how those two causes of actions interplay with the Michigan No-Fault Act. But first, let's discuss premises liability and ordinary/general negligence. So what are those two causes of actions? Generally speaking, when a plaintiff drafts a complaint for damages arising out of alleged negligent conduct occurring on a defendant's property, an important consideration that they will take into account is whether to plead a cause of action for premises liability, general negligence, or both. So why does this matter? Well, if we look at slide 2, the distinction is often claim dispositive. And that's because the defense-friendly open and obvious doctrine applies to bar many premises liability claims, but has no application at all to general negligence claims. As a brief reminder, the open and obvious doctrine under Michigan law basically defines it as a danger is open and obvious if an average user with ordinary intelligence would have been able to discover the danger upon casual inspection. Well, that's fine and dandy, but what is a premises liability cause of action? What is a ordinary or general negligence cause of action? How are they different? How are they the same? Well, the easiest way to decipher the two is as follows. Premises liability arises out of conditions on the premises under the defendant's control, while general negligence stems from the conduct of the defendant. This may sound simple now, but in practice, the distinction is not always as obvious, which is why we often see plaintiffs just plead both and say, defense counsel, you figure it out. However, you will come across some more experienced lawyers who will often attempt to describe and then artfully plead the same injury-producing event in terms more favorable to their legal position, which most of the time would be ordinary negligence in order to get around the open and obvious doctrine. So let's do a little exercise. And during this, ask yourself, was the injury caused by the condition on the premises, or was it caused by the conduct of the defendant? So for example, let's say that you go shopping at a retail store and slip and fall in a puddle of clear liquid that was spilled in an aisle. To decipher between premises liability and ordinary negligence, ask yourself the following questions. Was the injury caused by the unsafe condition on the premises? Well, in this case, sure. Or was the injury caused by the conduct of the grocery store employees in failing to clean up the spill despite having noticed it? Well, in this case, kind of. What sounds like a bright line legal rule in theory is less clear in application. But with respect to this example, as we'll see later on with interpretation of various cases, this example would likely be classified as a premises liability claim, as the injury was caused by the condition on the land, aka the clear liquid spilled in the aisle. Now, as you may start to see, some other examples get rather confusing. Thus, as we mentioned previously, in order to get around the open and obvious doctrine, plaintiffs will normally take two general approaches in their pleadings. First, like we discussed, they will just plead both. They will plead premises liability, focusing on the alleged dangerous condition on the land, and they will also plead a general negligence claim focusing on the defendant's wrongful conduct. Second, what they'll likely do is just plead general negligence, emphasizing the alleged wrongful conduct of the defendants rather than focusing on the premises per se. Very seldom will we see a plaintiff claim just premises liability because that is suspect to the open and obvious doctrine, which is so defense-friendly. But in response to these tactics, the case of Adams versus Adams at the bottom of the PowerPoint held, regardless of the pleading made by the plaintiff, it is well settled that the gravamen of an action is determined by reading the complaint as a whole and by looking beyond mere procedural labels to determine the exact nature of the claim. This quote in the Adams versus Adams claim is really the standard for deciphering between the two causes of actions. It's important to ask yourself, what is the gravamen of the action, aka what is the essence or the most important part? So let's talk about some cases. Slides 5 through 7 we'll discuss some published cases deciphering between the two, while the later slides will be unpublished cases. We'll then go through a chart that was published by the Michigan Bar Journal that kind of goes through a set of facts and any subsequent rulings by the court, whether or not it is premises liability and or general negligence. So first, let's talk about the important starting point with respect to these two causes of actions. It's the 2005 Michigan Court of Appeals case of Laier versus Kitchen. So what happened in this case? Plaintiff was more or less helping the defendant repair a farm tractor on the defendant's property. And during the repair, the bucket of the tractor moved as a result of the repair work, and in doing so, it pinned the plaintiff between the bucket and the tractor body. Plaintiffs then sued for wrongful death, alleging a single generalized count of negligence without really specifying the underlying theory of liability. The trial court granted summary disposition in favor of the defendant under the open and obvious doctrine. However, the Court of Appeals reversed the dismissal. The two main points that this case really stands for, and the two main points to take away from this case, are as follows. First, this case really distinguishes that there is a difference between premises liability and ordinary negligence, and it also establishes that open and obvious does not apply to ordinary negligence cases. So, by way of history, the Laier case in 2005 is really instrumental in establishing those 2 points, and from there we really go on and build off of that case. Next is the 2012 case of Buhalis versus Trinity Continuing Care Services. That can be found on slide number 6. Now, in that case, the plaintiff slipped and fell on ice on a patio near the entrance of a building owned by the defendant. Plaintiff in turn asserts both premises liability and ordinary negligence claims. The trial court dismissed the premises liability claim on the basis of the open and obvious doctrine, but the trial court refused to dismiss the ordinary negligence claim. Court of Appeals reversed that decision, and in doing so, the court held, and I quote, "If the plaintiff's injury arose from an allegedly dangerous condition on the land, that action sounds in premises liability rather than ordinary negligence." The court continued to state that this is even true when the plaintiff alleges that the premises possessor created the condition giving rise to the plaintiff's injury. So remember our example at the grocery store. That is why I stated that it is likely a premises liability claim. Now further, the Court of Appeals stated, applying the rules to the facts of this case, though plaintiff asserted that Trinity's employees caused the dangerous condition at issue, the allegation does not transform the claim into one of ordinary negligence. Therefore, the court ultimately ruled that her negligence claim is a common law premises liability claim. Now moving on, the case of Kwiatowski versus Coachlight Estates of Blissfield is really the only Michigan Supreme Court guidance that we currently have. And that case is a 2008 case. Unfortunately, the guidance is less clear and does not offer much help to practitioners or the bench whatsoever. A brief review of that case. The facts are relatively straightforward. Plaintiff lived at a mobile home park owned and managed by the defendants. On the date of loss, defendant opened a door at the management office. That door in turn hit plaintiff, causing the plaintiff to fall from a porch and sustain injury. The plaintiff initially filed suit against the defendants on a premises liability theory, but the court granted defendant's motion for summary disposition, but allowed the plaintiff to file an amended complaint to allege general negligence. The defendants again sought summary disposition with respect to the general negligence claim, but the trial court denied that motion. The Court of Appeals majority reversed that decision, and they found that plaintiff was not injured by the door hitting his face and chest, but rather the plaintiff was injured by his fall once he lost his balance on the small porch, when then he hit his foot under the door. The small porch and the slight gap between the porch and the door are conditions on the land. Thus, the Court of Appeals stated that plaintiff's claim arguably sounds in premises liability and not general negligence. Well, and then the Michigan Supreme Court gets involved and reversed the Court of Appeals. Basically, the Michigan Supreme Court found that plaintiff's claim was based on defendant's negligence in opening the door, as opposed to defendant's failure to protect plaintiff from the dangerous condition. Now, how to recap that mess? I'll just point out this. Kwiatowski stemmed from a simple set of undisputed facts, yet the judges of the split Court of Appeals panel and the judges of the split Supreme Court reached different conclusions about whether the gravamen of the plaintiff's claim involved a condition on the land or a conduct of the defendants. Lesson from that case is that the gravamen of plaintiff's complaint lies in the eyes of the beholder. This means in practice persuasive lawyering, as well as which member of the bench is making the decision, could make all the difference in a particular case. Moving on, since the cases we've discussed, the Michigan Court of Appeals has issued more than 12 or so unpublished opinions dealing with the matter and has provided some helpful guidance that can be found in those cases. Quickly, I'm going to go through some of them, and these can be found on a rather concise and well put together chart that was authored by the Michigan Bar Journal. For instance, the chart more or less deciphers and lists about 8 cases that the court ruled were in premises liability, and then about 4 to 5 that were in ordinary negligence. So let's first start with the premises liability cases. A case by the name of Berry versus Dearborn Heights involved a situation where the plaintiff fell off of a stage. Well, in that case, the court ruled that it sounded in premises liability due to the injury being caused by the condition on the land. Another case is Duprass versus Lloyd Lee, and in that case, the plaintiff slipped and fell on a wet roof after the defendant implied that it was okay to go on the roof. Like the Berry case, the court also opined that the case sounded in premises liability as the injury was caused by the wet roof and not by the defendant saying, hey, plaintiff, it's okay to go up there. Quite like the example we started the seminar with, in the case of Thorne versus Great Atlantic, plaintiff slipped and fell on grapes in a grocery store. Court held that that was a premises liability claim as well. Now, with respect to ordinary negligence claim, in the case of Perkins versus Mid-Michigan Recycling, plaintiff driver fell off of steps off of a large front-end loader on the defendant's property, and the court concluded that that was a claim of ordinary negligence. Another one is plaintiff fell and broke a bone while walking across the parking lot, and that was due to defendant's conduct in that case. So the court opined that ordinary negligence was the right decision. In summary, based on the cases that we've gone over, and whether published or unpublished, if there is a focus on a defendant's actions in the absence of a premises liability claim, or if a physical act by the defendant directly caused the plaintiff's injury, it's more likely than not a viable claim of general negligence may be allowed. But if it is just the condition on the land that causes plaintiff's injury, it is likely that a court or trier fact will find that the claim sounds in premises liability and thus would be subject to the open and obvious doctrine. Now let's shift our focus from strictly premises liability and ordinary negligence to discuss how those two causes of actions interplay with the Michigan No-Fault Act. And generally, you will see an overlap with the two within the parked vehicle exception of the Michigan No-Fault Act. And that is accidents involving parked cars and other vehicles, which are addressed in MCL 500-3106, subsection 1. And that section states that an accidental bodily injury arising out of a parked vehicle is not compensable within the no-fault benefits unless the injury falls into one or more of the three exceptions. For this webinar, the most suitable exception here would be subsection B, and that is injuries occurring as a result of contact with vehicle equipment or with property being loaded or unloaded. Now, with respect to that, as a general rule, it has been held over the years that to be eligible for first-party no-fault benefits when an injury involves a parked motor vehicle, MCL 500-3105 requires that the injury arise from the injured person's use of the motor vehicle as a motor vehicle. That is, the activity giving rise to the injury must be closely related to the vehicle's transportational function. Well, what the heck does that mean? If we look at the case cited here, Kemp versus Farm Bureau, it's a 2015 case, and in that case, plaintiff sought first-party no-fault benefits after injuring himself while falling in his driveway. When the plaintiff fell, he was allegedly unloading personal items from the back seat of his pickup truck. At the trial court level, Judge Susan Borman, who was still on the bench of the Wayne County Circuit Court, granted Farm Bureau's motion for summary disposition, citing that plaintiff's injuries did not have sufficient linkage with the use of a motor vehicle because the causal nexus between the injury and the motor vehicle was merely incidental. The Court of Appeals disagreed and held that plaintiff was entitled to no-fault benefits. And why did they do that? Well, the Court of Appeals found that plaintiff's bodily injury arose out of the use of his parked vehicle, i.e., his property being lowered from the vehicle in the unloading process. Well, the Michigan Supreme Court disagreed with the Court of Appeals to the extent that it at least creates a question of fact. But in so holding, the Michigan Supreme Court simply stated that the question of fact exists with respect to whether plaintiff satisfied the parked vehicle exception and whether the corresponding causation requirement of the injuries related to the accident. But in doing so, the Michigan Supreme Court did clarify that, generally speaking, unloading property, such as personal effects and the like, from a vehicle upon arrival, which is a big distinction, at a destination constitutes use of a motor vehicle as a motor vehicle and satisfies the transportational function requirement, and therefore the plaintiff will be entitled to Michigan no-fault benefits, and it would not be based on a cause of action for premises liability and or general negligence or ordinary negligence. All right, well, that's it for the presentation. If any listeners have any questions, please call me directly at 248-539-2830 or email me at jgrimske@secrestwardle.com. I would be so happy to embark on any of the cases that we discussed or just talk about any issues that you may have or go over the chart that was authored by the Michigan Bar Journal in more detail. Until then, look forward to talking to you soon.